Welcome to This Explainer. Today, we're diving into a really fascinating analysis of the public record. And right away, it reveals a stark contradiction regarding the massive financial obligations placed on U.S. tech companies by the European Union. You see, while those record-breaking penalties always generate massive headlines, the actual verified flow of capital tells a much more complicated story. To really separate those headline announcements from legally binding realities, our audit today is going to cover gross fines versus final reality, mapping the legal mechanisms, why taxes are not punitive fines, where does the money actually go, regulation versus industrial policy, and finally, the unresolved pending appeals. All right, let's jump right into Section 1, gross fines versus final reality. We absolutely have to start with the massive gross figures that have been formally imposed on the tech sector. Since 2004, a staggering gross total of 22.366 billion euros in public sector regulatory fines has been imposed on major U.S. technology firms. We're talking Alphabet, Apple, Meta, Amazon, and Microsoft. Now, this cumulative figure perfectly represents the sheer scale of the headline announcements we all read, but here's the thing. It is not the complete ledger. That's because we have to look at the subtraction ledger. Judicial Review has actually subtracted 3.633 billion euros that was definitively annulled or reduced by European courts. These courts are actively scrutinizing the regulators, which is their job, plus there is another 9.601 billion euros that remains completely unresolved under active or expected appeals. So what does that mean? Well, it means that money hasn't been finalized, let alone paid out. Consequently, the actual legally final and valid amount currently stands at a much smaller 9.132 billion euros. When you filter out all the overturned decisions and the pending litigation, the confirmed liability is literally less than half of that giant gross imposed amount. It's really a process of judicial attrition. It brilliantly demonstrates how European courts actively check and adjust regulatory actions. So while those gross impositions represent these towering initial figures, the reality is that rigorous judicial review and pending appeals shrink the true legally binding reality down to just a fraction of those initial headlines. Okay, let's move on to Section 2, mapping the legal mechanisms. We really need some category discipline to understand the legal foundations of these varying amounts. EU interventions actually reflect a very distinct shift from traditional competition enforcement over to new platform and data regulations, and this spans across different corporate divisions, like app stores and search. First up, we have ex post competition law under Article 102. This is essentially the historical mechanism for penalizing abuses of market dominance. Cases like Google Android and the historical Microsoft fines fall into this bucket. And these aren't quick. They often take a decade of incredibly complex economic analysis before they ever reach a final resolution. Conversely, we have the Digital Markets Act, which acts as ex ante regulation. This enforces rapid structural mandates. So instead of waiting years to prove market harm after the fact, regulators establish the rules upfront for designated gatekeepers. And as you might guess, this leads to incredibly rapid enforcement timelines that we are actually seeing play out right now. Separately from all that, there's the General Data Protection Regulation, or GDPR. This framework empowers national supervisory authorities to levy massive fines based on global turnover for privacy violations. It's important to note this is a completely distinct legal framework from competition law, and it's primarily driven by national bodies rather than the Central European Commission. That brings us to Section 3. Taxes are not punitive fines. This is absolutely crucial. State aid tax recoveries operate under an entirely different mechanism and must never be grouped with punitive fines. A punitive administrative fine penalizes specific behavior. On the other hand, a state aid recovery is simply the retroactive restitution of an unlevied corporate tax. We have to keep this category distinct when examining the overall ledger. Basically, an entity is either being punished for a behavioral violation or it is simply paying back a baseline tax obligation. To put that into perspective, this distinction is critical in the well-known case of Apple, which transferred 14.244 billion euros to the Irish state. They were completing a tax obligation rather than paying a fine. The vast majority of that, 12.677 billion, was simply the tax principal owed. The remaining 1.567 billion actually came from net interest and investment gains that were generated while the funds just sat in escrow during the litigation. Next up is Section 4, where does the money go? We have to track exactly where these finalized financial obligations physically flow. A transaction-level review confirms that the collected capital overwhelmingly flows to the EU general budget or to specific national treasuries. If it's a confirmed antitrust fine, it enters a public budget. If it's a tax recovery, it goes to a member state's exchequer. Meanwhile, claims from private European companies currently remain unresolved. Now, here is a truly surprising reality from this analysis. 0 verified consumer cash distributions were identified within the reviewed cases. None. While these regulatory actions are very often framed in the media around protecting users, the actual collected capital physically flows into government accounts, not directly into consumer pockets as financial redress. And the unresolved exposure extends even further into civil damages. This is highlighted by a 14.3 billion Swedish kroner judgment awarded to PriceRunner, which both parties immediately appealed. This represents a massive potential payout to a private European company following an antitrust ruling against Google. But because of those immediate appeals, it remains an unresolved liability right now, not collected cash. Let's look at the bigger picture in Section 5, Regulation versus Industrial Policy. Given the massive scale of these interventions, two highly distinct interpretations of EU policy have emerged in the public record. On one side, the European Commission asserts these actions are completely necessary market corrections, and they point to legally final judgments to validate their push for fair competition. On the other side, the tech companies dispute this, arguing the rules act as a form of industrial policy that degrades product security. They often point to the annulled fines as evidence of overreaching theories that unfairly penalize successful business models. Furthermore, we can't forget about the unquantified costs. Behavioral remedies mandate non-cash operational changes that become deeply embedded in corporate accounting, and these just cannot be reliably quantified as a cash minimum. When a company has to re-engineer its core search display logic or allow third-party billing mechanisms just to comply with the DMA, those operational shifts divert massive revenue margins. It's basically a hidden cost of compliance that never shows up on a fine ledger, but it radically changes the business. Finally, Section 6, the unresolved pending appeals. Ultimately, the final ledger is a moving target. The timeline compression enabled by the newer regulations shifts compliance to an immediate operational prerequisite. This is triggering a rapid cluster of new fines and appeals through 2025 and 2026. This fast pace contrasts really sharply with those decade-long antitrust investigations of the past. New multi-million euro DMA fines are being rapidly imposed, while simultaneously, massive historical fines are being successfully annulled in court. So what does this all mean? With 9.601 billion euros still unresolved and under appeal, how will these pending judicial checks ultimately rewrite the final legal ledger? While the headline numbers remain absolutely staggering, the courts always hold the final pen. As new rapid regulations clash with prolonged appeals, the true finalized cost of compliance for major technology firms in the European Union remains a very open question. Thanks for joining us for this analysis.